This video is being shown to you under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, education, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Hit the like button. Let's go.
What's up? What's up? What's up? It's your girl Survivor Speaks, and I'm here with a live video. So I know y'all saying, Survivor, what is you up? What are you doing up 1:33 a.m. live streaming? Well, I'm having a hard time sleeping. A lot of things on my mind. I have, some things that I'm getting checked out health-wise, but your girl is okay nonetheless. So being that I can't sleep, I wanted to take advantage of this time and come live because, as you may or may not know, I'm starting to use a new system, so I have to learn it, but it's been challenging. So today I'm streaming from my old trusty system. All right. And so today's I'm gonna do a rewind on the I don't know how I missed this, but I did miss this. So I'm rewinding a hearing that took place on October 4th of 2024 prior to Sarah Boone's trial. So now in this trial, in this hearing, she was trying to get the interrogation video tossed out. She said that she was not read her Miranda warnings completely. And so she wanted the judge to throw out the the interrogation. Anybody that's familiar with this case knows about the interrogation. So we know that Sarah, without being prompted, when she finally called the police after being convinced by her ex-husband, because she called him first. So she wanted him to tell her what to do. He's like, call the cops. Oh, come inside. Brian was like, no, I'm not coming inside. I'm not doing that. We're not doing that, Sarah. I'll stand out here, support you from the outside. I'm not coming in your house. You're not going to tell these people that we got together somehow and we did this thing. So, he was smart about that, Mr. Boone. Shout out to him. Shout out to Lucas. That is Sarah Boone's son. I feel sorry for him, but at the same time, he's a lot smarter than his mother. And he finally got to tell her how he felt. So I know I covered this case a little bit, but I don't know how I missed this hearing. So the hearing, like I said, that took place on October 4th of 2024 was, they were trying to get the investigator, Chelsea Koespel. They were trying to get the interrogation video tossed out. She was one of the investigators that was, a part of the interrogation. And so, but no, Sarah, wait a minute, hold on, pump your brakes now. So, let's see how it all went down for her. So I think I'm going to bring this on and put it on, 1.5. So, that we can get to the video. I'll stop it periodically and I will, do some commentary on it. So shout out to Lauren Crime. This is a video that I'm using under the Fair Use Disclaimer Act for educational and purposes and, whatever have you. So, this detective she knows her stuff. She handles herself well on the stand against Sarah's attorney, Mr. Owens. Now, Mr. Owens gets on my nerve. I'm just going to say that. I'm sorry. I mean, and I understand he's defending his client, but, sometimes you can go too far. So I do totally think that Mr. Owens went too far And and you're going to see how he was hammering this mute point over and over and over again, and asking this detective, trying to elicit some testimony from her based on what Sarah Boone told him. Nobody else but Sarah Boone. But it didn't work. But before we get started on the show, I just want to let you know that this show is sponsored by Restream. You can click the special link down in the description. You can make a free account. Of course, you can check out the other packages that they have, and they may, they cost, depending on what your preference is and, what it is that you're doing. But I just want to let you know that you can use my special link below and go ahead and set you up um, an account for yourself. Okay? Hashtag ad. So, as I stated, I'm going to bring up, we're going to just start this right away. It's already, oh, happy Christmas Eve, y'all, for the people that celebrate. I'm not celebrating. I'm not doing anything. I'm actually probably going to be sleeping, because your girl's been going through a little something, you know what I'm saying? Just going through a little something. And, it is what it is, but I'm gonna be all right. I'm gonna be all right. You know, the best thing that I could do for myself is to, stay the course, and till we figure it out, right? So hopefully today we won't be struggle streaming, and you guys are probably sleeping, getting ready for your Christmas festivities. Catch it on the replay. Just smash the like button when you come in here. And your girl is late today because, like I said, I was just, handling my own personal health business, my business. Shout out to Empress Fox and the leader. So she was not in Atlanta. However, she did live stream the peaceful protest for Diamante Kendrick in a YSL trial, professionally known as Yak Gotti. As we all know, he was found not guilty, on all of his charges, yet he's still fighting for his freedom in the Fulton County Jail. And sadly, he is going to be spending Christmas there. That's horrible. That is horrible. As a matter of fact, let me go ahead and make sure, because I know I scheduled this for 1:30 a.m. right before I went live, and I did not change my banner. So I just want to make sure that what is scrolling across should be scrolling across. So it is about Yak Gotti in here. You see how God is so good. It's about Yak Gotti, but this video is not. So let me go ahead and make sure that I have everything that taken out that should be taken out. Shout out to Miss Tasha. That is you know what? I think I'm going to leave this here. Yes, I am. So this banner says, so you know what? I was trying to go live and live stream the protest earlier, but I was on my phone. I was not home. And so it didn't work out for me. So I did have this here, and I'm going to leave this scrolling on through. Here it says how the Cash App is Cash App Free Yak Gotti. And that money will go to his mother, Miss Tasha, and put to good use, because, he has to now he has an attorney right now, but according to her, I don't know if he's going to continue to keep the attorney that he has, and she's going to be, looking to get him another attorney. So I guess I'll go ahead and leave that scrolling across the window. If you want to donate to Yak Gotti, feel free to do so, because no one should be incarcerated when they were found not guilty by a juror of their peers. Now, he did get another charge while incarcerated. However, he is fighting for his life. There has been several attempts to unalive him, and the most recent was he was stabbed in the top of his head, and he has stitches and staples on the day that he was found not guilty. So he has to defend himself. I don't think that anyone should be able to take that right away from him. We have a right to defend ourselves with a firearm, if as long as you are it's legally enrolled. So just because you're incarcerated don't mean that you let people beat up on you and, oh, I don't want to get in any trouble and go to the hole or things like that, so I'm not going to defend myself. So if he didn't defend himself, he may be out of here today. He might not, he probably wouldn't be around. But other than that, yeah, we're going to go ahead and do that one. And shout out to Miss Tasha. The protest was a success, and it did remain peaceful. And I'm so proud and happy, for that, because people are just looking for a reason to, um, people are looking for a reason to, to have something to say, but they didn't give them anything to say, so they can't say that one. So shout out to Seti Nash, Empress Fox. I'm gonna call her Lady Pink. Um, this sister, she has a YouTube channel. I subscribed to her yesterday, and you know what? I need to continuously, y'all know I got chemo for brain. I need to continuously say her name until it registers in my mind, so I'll believe it. So I'll remember it. I said, so I'll believe it. So I'll remember it. I just think she's a whole vibe. The pink hair, she has these glasses, like this, very stylish, all on her own. Shout out to that sister too. She's always there representing for them. So shout out to all of the people that showed up, participated in the protest, just to let the people know that we are still watching, even though the first half of the YSL trial is over. We are still watching. So give me 1 second here. I just want to uh just put a message over here. Um all right. So give me 1 second. I'm just putting a message over here. I just need to make sure that I do, and I need to keep an eye on the chat because I did not turn Nightbot on. I wasn't expecting anyone to be here, so my mods, they'll probably sleep. They just were on another live, some of them, and so they probably won't be in here. But anybody that comes in and it is a member, please do look at the new emojis that Survivor Speaks created today. And so that's what I was doing when I came, when I finally got home. I was just laser focused on getting that done because I was supposed to have gotten that done yesterday, but things happen, time flies, and my daughter, she's always needs to be picked up, dropped off, something like that. So I gotta do what I do, as a mother first. So just give me 1 second. Let me finish. Yep. And we're gonna get started. 1 moment. So yeah, so while I'm doing this, I'm almost done. There's a lot of stuff going on in these streets. I'm not going to talk about it. I'm going to stick to the topic of what I was talking about today. But there's a lot of stuff going on in these streets, stuff that I do and don't post about. And so hold on a minute, because let me just see this, because who was this? I was looking at people like, hold on now, who was this? All right. Yeah, because I don't, the trolls, go on ahead. Go on with it, Cletus. Go on with it, Cletus. I ain't got time. That's not what I'm here for. So I'll just leave this in just the way it is. It's not a show about, Yak Gotti already. Like I said, protests happened. It was from 10 a.m. to 1 p.m. This afternoon, and it did go off without a hitch, and it remained peaceful, and that's all that you can ask for at this time. Hopefully that if you're ever, going through something, that you'll have someone that can intervene and fight on your behalf, as well as the social media. I'll call them the social media. What am I going to call them? The social media nation. So I think it was more of the YouTube world and the Twitter world combined together that, actually kept this thing alive, along with some of the news channels and stuff like that. And it's really, really, a good thing, because a lot of people, we've networked, and there's still another half to this trial, but I'm not sure about that. So I'm going to leave that for another day, because it's a lot going on. Fani, I guess she said her name was Fani. We don't know how to spell it. We wasn't there when she was born, and we wasn't there when her mother pronounced what her name was. So we don't know how to pronounce it. She said Fani, I say Fanny. Listen, I'm not your cousin, your sister, your aunt, your niece, none of that. So listen, sometimes I might say Fani if I remember, but Fanny does me just fine, girl. It is no defamation of anything. At least they're not calling you something else. Like, over there, if you go on Twitter, you'll see all the other things that she's, being called, and deservingly, right? So yeah, I just, if you have a child, brother, uncle, nephew, you will want somebody to stand up for them as well, or in the gap for them when they're fighting for their lives, and especially when they were found not guilty on all their charges. So that means that they came up with this. He's on probation. They violated his probation. But wait a minute. When you guys arrested him for this fake case, that warrant should have the warrant should have been dropped then, because he's in custody. Okay, so now he's found not guilty. Then his probation officer should have lifted the warrant. They didn't have no charges against this man anyway. Only charges he has is a new charge that he got while being incarcerated, trying to protect himself, trying to keep himself alive. It's really, really disturbing to look at all these things. Like I said, you have men in your family too, just, pray for his mother. I did a live, and I did play the video of her when he was found not guilty, and she, from her gut, thanked everybody and did all of these things only to not have her son home today. I don't care how old he is. That's still her child. Sometimes, you don't agree with your parents. You don't listen to your parents sometimes when it comes to certain things. But nonetheless, that is still her child. All right. So let me bring this video over. Let me make sure that it's on. Okay, yeah, it's on. I'm gonna do 1.5. I might even increase it to 170, 1.75, depending. But this fool here, she's a whole mess, because your attorney, you don't even give your attorney enough respect to let him do what he does and to handle your case. Why is you testifying all in this hearing, Sarah? I'm not understanding. But her attorney probably told her that it wasn't a good idea. And knowing the Sarah Boone that we have come to know, she don't care. And so, yeah, this is what I had set up earlier when I couldn't even. So there is the Cash App for Mr. Yak Gotti. It'll go, the funds goes to his mother. She has to fight to get her son out of jail. It's a whole mess. And I wouldn't wish it on anybody. Because what I think is that Fulton County has been exposed, and I cannot wait. I cannot wait for them to go down there and tear that sucker down. Let's go. Go down there and tear it down. Fannie needs to be removed immediately. You don't waste the taxpayers' money in Fulton County. This trial wasn't a win, but you just have a lot of men caught up in a web that they're going to have a hard time getting out of. But a lot of people voted. A lot of people voted, and in cases like these, we don't know where we're going for 2025. I hear all types of stuff, and I try to stay away from political things because it's just not healthy to consume that stuff all the time. But we don't know where we don't know what we got. I already feel like I live in a goddamn third world country. But anywho, nonetheless, let me bring this up and let's start it. So we're going to watch the beautiful investigator Chelsea Koespel on the stand. She's everything that Sarah Boone wants to be and more, but she cannot. Just be yourself, Sarah. I don't know what you were thinking about when you said some of these things, Sarah. I don't know what you was thinking about. But you said these things and they don't make any sense. And you can tell that her attorney was saying like some of the same things or all of the things that Sarah told him. He had no firsthand knowledge. He did not even ask for the card where the investigator was reading the Miranda rights from. So he kept trying to hammer on this point, and like the judge finally told him, "Listen, that is not what this is. That is not what this, like you are. This is not the trial. Pump your brakes and hold on." The Miranda warning card that she used does not have that 9th Miranda warning on it. So therefore, you keep trying to say she didn't read it. It's not on the card that she had. And they said that it's just something that they add at the end sometime and they don't. Just to kind of like bring everything that they said in the Miranda warnings 1 through 8. They sum it up in Miranda number 9, but it's not the law. It's not. He kept saying, is it protocol? Is it protocol? Is it No, Sarah Boone told you that. You got that from Sarah. You got that from your client. Yep. You got that from your client because she is a whole goddamn on fool and she doesn't know when to. So yeah, so we gives none. Because she don't know how to shut the F. So we give no F's. Right? Okay. Let's go. And she was pregnant at the time of the interrogation. She done had that baby. She came in there. When I tell you she was stepping, she came in there stepping today, here in layers and stuff like that. In the interrogation room, I remember her being sick and she had to hear something like it's just flat. And she came in today, had a little Farrah faucet flips on the side. Like, I'm not mad at you, Miss Chelsea. I'm not mad at you. Let's come on, bring it on over and let's get started. Like I said, if it's not too fast, I might move it up just a tad bit more, but we're going to get her off the stand because, I have used that to, just make me a little thumbnail. And so, yeah, sometimes you do that there. Okay, here she got.
Chelsey. Last name is Koepsel.
Thank you. Counselor, you're in court. Thank you. Where do you work, ma'am?
Sheriff's office.
What do you do for Sheriff Nina?
I am a homicide.
How long have you been a homicide detective?
Over 6 years.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I'm around 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So, for this case specifically, my team was on call that week for homicides. And so, on the scene, to notify the call center, to notify the on-call homicide.
Hold on 1 minute, Joel. Let me see something. Because I don't like that sound. It's not giving. What's going on?
All right. And is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first, or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence?
Yes.
And later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes.
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's up here on my left, and she's wearing blue.
May the record reflect she's identified the defendant?
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott alone with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in an unmarked Pathfinder, so it was like gray in color. Didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights looking like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat. Sarah sat in the front passenger seat, and Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct, I did.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, of course not.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was.
And when was that?
That same day.
I mean, when time-wise in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs, and so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. I go back to her house.
Prior to that, has she been detained and requested not to leave the scene?
Right.
Prior to your interview with her in the car, has she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the Sheriff's Office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the Sheriff's Office rather than you returning to the scene?
Yes.
Can you explain that?
It's for a control setting for law enforcement. We were able to audio and video record at the Sheriff's Office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the husband's residence where her potential child was, so I just thought it was a more controlled setting at the Sheriff's Office.
All right, and when Ms. Boone arrives at the Sheriff's Office, who goes down to greet her?
Shout out to the people that's in the building. You can hit the like button and it won't tell me who you are and that you are here. So shout out to you, but hit the like button if you are in the bushes. I won't know who you are unless somebody comes in and drops some membership on you. And then, well, you still may not get the membership, but hit the like button if you're here. So I'm just rewinding. I missed this just to give you a quick rundown. So this is a hearing prior to Sarah Boone's trial. I don't know how I missed this hearing with the lead investigator, Chelsea Koespel, who's on the stand. And they were trying to get the interrogation video thrown out because actually, well, from the time they came out on the scene, Sarah had started talking. They didn't even ask her any questions. She began to talk. And she just basically just rambled everything off and said what it was. And then, in the interrogation room, it really showed who she was as a person. So it definitely hurt her. So this attorney that volunteered to take her case pro bono, he was trying to get her case thrown out. You will see him come up after the state finishes questioning her. And he is quite the handful. So smash the button if you're here. That's a good that's a rundown of what we're watching tonight. And I am watching it on speed 1.75. So if you're in the building and you care, just say, hey, it's going too fast. Can you slow it down a little bit? All right, here we go.
And where?
It was not me. But she would have gone in through, we have two entryways, so either on the record side or on the opposite side. And she would have to go up to a window and request that she was there to meet with me. They would call me. I would tell them, yes, sign her in. And then, if I'm not mistaken, I believe Detective Owens went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through?
Yes.
As opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card?
Yeah, the public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the Investigation Division's interview rooms?
They're located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination? Yes.
Detective, I'm James Owens. I met you outside just a few minutes ago, and I represent.
Buckle up, because here we go. And I just want to say that this attorney, he rubbed me the wrong way, and it's just me. But I got a right to my own opinion, and yeah, he rubbed me the wrong way. But here we go, and he better stop it before I get Nene leaks. Don't make me. Don't make me call Pasha.
Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Owens, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or
And-
down the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the password or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
Or do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, your testimony is you asked her for a password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right, you're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, did you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
And the cash sheet says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle or you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out and then went into her phone, and then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This is 2020.
Okay. If she recalled that, would you dispute it?
Say it.
Your testimony is you don't remember saying that.
I don't remember specifically saying one more time. What is it that she claimed I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car? Or
Yeah.
standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my car, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
Of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is an emotion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because it's the policy of her department.
But what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
Remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights, and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames, not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite of the apple.
I'm sorry?
Last bite of the apple. Last bite of the apple. Any other argument?
We're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then
Hey, Electro Jet, thank you for joining. Make sure you hit that like button just to give you a quick rundown. I don't know how I missed this video. This is about the Sarah Boone case. This is a hearing prior to the trial where they were trying to get the interrogation video tossed out. And so this was a hearing. The lead detective is on the stand. She was awesome then. She is awesome now. This attorney took this case pro bono because Sarah had been through 8 public defenders. She could not get along with anyone. And the interrogation video really shows who she is as a person. She does not even have the decency and did not show one bit of remorse for George Torres. May he keep resting well. And also, she has a son that she uses as a pawn. She only talks about her son when it is convenient to her. So I'm going to get right back into the video. I'm playing it on 1.75. If it's too fast, let me know, and I can always go ahead and slow it down. But this attorney here is a hot mess, and but he couldn't shake this detective. And, you know, I'm proud of her for standing her ground because this is disgusting. But anyhow, I'm going to move on.
And question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? Mr.
You
Judge?
keep calling the defendant by first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's
Okay.
fine. You may proceed.
Yeah, like she's your equal.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Yes.
Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions? This
Correct.
Here you go again. This is
not 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my warrant card, but
I'm sorry?
It's not on my record that I read from.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card.
That's what she said.
We have multiple Miranda cards at the sheriff's office, but yes, that is the policy. In reference to the policy, yes, it is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Sustained.
did you fail to get the most updated card, or how did that happen? That the ninth question was not on your Miranda rights card?
I've had that card since I started being conducted in sex crimes, 2013.
Have you become aware, as it relates to following this motion,
I've become more aware, yes, that there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
What is the question for?
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back?
No,
You did not tell her that.
no, I listened to all my interviews, everything that's been audio recorded, no, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I did give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant, because I don't need to tell her that. It's evidence in a crime, I'm allowed to take it, so I took it, and I wrote a search warrant for it.
Okay, but you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Okay.
Hold the heck on her husband's phone. That Sarah is not married to Brian. They have not been married for a long time. She just was continuing to get this man's money. Come on now, Attorney Owens. Now, come on, stop. Come on with the come on and stop that. That's not that man's husband. She decided, that she wanted to be married to the model. So what are we talking about here? I mean, I just had to say that. What do you mean? She didn't call you from her husband's phone? Sometimes this attorney makes me just want to just that one right there.
Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered it, yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
Okay. At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
No.
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her come in the afternoon,
I believe it was on 3 p.m.
did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would look at the phone.
Okay, do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know. off the top of
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
my head. Yes.
Okay, and would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right, and what time was the autopsy that morning?
It starts at 8, but I did probably get up till 10. It takes quite a few hours.
Okay, and were you there alone with the medical examiner, or was it anybody else there?
I don't recall if Detective Long was with me or not, but yes, of course, there's doctors there.
Okay, and so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she...
I'm confused. I'm confused, Attorney Owens. I'm really confused because what the flying did you think that they was going to do with her? She put this man in a coffin, a suitcase. It was, turned out to be his coffin. What did you expect them to do when she came back down to the station? This hearing was unwarranted, and I don't think that they should have had it. And like I said, I'm not sure how I missed this, but this is very interesting. And Mr. Owens, I think you should be a little embarrassed because this is kind of this is not this is not, you're repeating everything that Sarah told you. Did you at what point did you find out, or did you ever find out that Sarah Boone is a compulsive liar? I'm not sure if you found that out, but you didn't do hardly any investigation, sir, because almost everything that Sarah Boone has said during this case is a lie. So I'm not understanding, what did you think that they were going to ask her when she came into to the police station? Did you think they were going to ask her, did she want to have some freaking tea and cookies? Oh my God, this guy is and just, draw your own conclusions, but this attorney here is a piece of work.
She exercised or invoked her rights to remain silent, that they were going to arrest her anyway. That they had already made a decision. She was the prime suspect. They had probable
What does
cause.
that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
Us.
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right?
Hang on. Before we ask any questions, let's drill with the evidentiary objection first. The objection sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not going to be free to leave.
Excuse me?
She was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
Objection, relevance. This is what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all that information.
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before in reference to the injuries that you failed to mention.
And you also wanted to question her about the two videotapes that you had found on the phone.
Objection, relevance.
Overruled.
Yes, I wanted to show her the videos.
And you agree, in your opinion, the two videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question again.
You agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection to the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, relevance.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
It was Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not read your motion.
Okay. Do you recall you saying to her, I'm going to have you sit in the green chair?
Objection. As evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay.
So yeah, the best evidence, when they say the best evidence is the recording, that means that they're not willing to take anything that you're saying out of your mouth, any documents that you took and transcribed, you probably put on the transcription what you thought you heard, but the law is to go ahead and listen to the evidence because they have that on the video. They're not going to allow, the judge is not going to allow him to stand in court and say, did you read a transcription that I made, when they have video evidence? So the video evidence is the best evidence for them to view during the trial. I don't understand why he's asking all of these irrelevant questions at this point in this hearing. I am not a lawyer, and I understand that to be the freaking law. The best evidence is if you have video of anything, that's the best evidence. An attorney should not be transcribing anything because he may just be putting down what he wants to put down on a transcription, and it's what is in the best interest of his client. So that's what, when you hear them say best interest, because they're going to say it often here to Mr. Owens, that's what they need.
Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
As evidence.
Sustained.
Best evidence.
Do you recall making some comments to her prior to reading her the rights?
Objection. As evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013.
How long have you been a homicide detective?
Over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and I wished to have a conversation with her.
Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection. Relevance.
Overruled.
I did not ask her question number 10.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
Move it right along, sir.
Yeah.
Yes, this is our waivers and affidavits.
Is that filled out on waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And that form filled out as it relates to Sarah Boone?
We're talking about just this top, right? Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature below?
Yes.
Did you see her sign it?
Yes.
Is that her signature below?
Yes.
And is that the consent for the form?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper?
Yes.
That's audio and video recorded? No.
Okay, you would agree that there's no questions on the form?
Yes.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding Florida's state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Your response?
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision. I'll talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after
Yeah.
questioning. If you can't afford one will be provided to you.
Take 'em to
Everything you say
school.
can and will be used against you. Those are the things
Take
that
'em
Miranda
to
highlights. The
school.
Miranda opinion itself says that. So what does question number 9 have anything to do with
Take 'em
those
to
things if the state
school.
case law and the federal case law, including but not limited to Miranda itself and Powell? And then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as
First of all, like you just said that she's only required to read 4, but I've never really heard of an attorney that comes into the court and has an issue with the detective reading Miranda rights to his client. Like, I feel stupid.
relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights, different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, at the time of the interview. Yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay. That's all the questions I have at this time.
Any redirect?
Okay.
All right, can this witness be released?
I'd like you to stay.
All right, subject to recall. Thank you.
Thank the good Lord.
State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Judge, I would like
You stipulated to the intervention.
All right. Now, any
No, I don't
other
wanna check the
any
authenticity.
other person in this case, in this point in the trial, would let the attorney do what they have to do and leave. But in Sarah's case, she just cannot let things go. She knows that she's guilty, but she feels like she is the smartest person in the room. She didn't do anything wrong. Poor Sarah. They're picking on me. They didn't do that. I didn't do anything. If you haven't seen the trial, just go to the day of her testimony, and take a look at that. So after watching this trial, it is the opinion of Survivor Speaks that Sarah Boone, this was premeditated. Watch the video, watch her on the stand. You cannot miss any parts of that, because you will miss it. And then I did do a video on that. And I also did show the video of George on the ground, balled up in the fetal position. And she was emasculating him. And I don't think that, a man should be talked to like he's 5. And to see him like retreat into himself, it was hard to watch. Also, and then it was just disgusting. So this little angel that she portrays on the stand, that's not who she is. And anytime that she brings her son up in this case, it's something that she's using him as a pawn for. She wasn't taking care of her son when she was on the street. His father was. She would not be on time to get the young man from school, and the father had to often call her to ask her, are you going to be able to or available to go pick our child up? And on the day that this happened, she called the husband over there. And once all of the people got there, let me give you a little caveat before she gets her dumb behind on the stand, because apparently she was never ever taught to. So she talks, ad nauseum, and then she says all these things, and they come back to bite her. But so she's going to on the stand talk about all of this stuff that is irrelevant, and she's going to talk about how she was so startled and everything behind everything that was going on. All of the cops that were there and all of this other stuff. I just want to let you know that Sarah Boone had contact with the cops on a weekly basis. George was like any woman that's abused. I know some people are small-minded and don't believe that men are abused as well. It goes both ways. George, so Sarah would call George to the home. He would, they lived together. They drank. They fought. She would put him out, so he had an order that he couldn't be there. But then she would call around to find him, tell him to come to her house, and when he would get there, she would call the cops and get him arrested. And when you look at the when she's on the stand, and once the state starts playing the evidence, Sarah Boone set this up. This was premeditated, in my opinion. This was premeditated. She knew exactly what she was going to do. And just in case you didn't see the trial or you're not interested in the trial, it came out during the trial that she actually beat this man with a bat before. We don't know whether or not she was beat. Was forced to get into the suitcase, or if she was or if somehow she waited till his back was turned and she knocked him into there, and he was still alive in the suitcase. So I mean, it's very disturbing to hear him begging her to let him out of this suitcase, and she just leaves him in a suitcase to perish. And the first lie she told was that they were playing hide and go seek. And he decided, they thought it was so funny, he was going to get in the suitcase. But then she tapes for a little while, then she turns the camera off. When she turns the camera back on, you can see that George, the suitcase is flipped over. So she actually, I don't know what she did, if she beat him some more when she turned the camera off, and then she turned the camera back on, the suitcase was flipped over a different way. It's quite disturbing to watch. And she's where she needs to be, just in case you don't feel like watching the trial. She's where she needs to be. Shout out to Judge Kranick, because he has the patience of Job. I'm going to give him what I call the lead attorney horn. I'm going to give him one horn. One lead attorney horn, please. Because she's a lot. And so the medical examiner did testify that there was no way that George was beaten once he was in the suitcase. Based on the examination, that he had to be beaten before he got in the suitcase. And so, just like, I know a lot of times when people say, people are abused, automatically you think of a woman. But in this case, I do believe that George was an abuse victim. I believe that she premeditated this unaliving, because she said to him when he was in the suitcase, "This for everything you ever done to me. For everything you ever done to me." He's like, "Sarah, I cannot breathe. Sarah, babe, I can't breathe. I'm not playing." She's like, "F you." He's like, "I cannot breathe." When I tell you, it is heartbreaking to watch. And I have another video where the sentencing hearing, his family was in the courtroom. When I tell you, that was the most disturbing video that I've ever, watched. And I'm an avid trial watcher, interrogation. I'm into all that type of stuff. So I'm always watching trials, especially ones that are going on live. And I implore you, you may not want to see the video to hear what she said during her hearing. She re-victimized him all over again, in front of his mother, in front of his sisters, in front of his brother. Not just him, she also slandered his whole family, his entire family. And it was so disturbing. She is where she needs to be. And I can tell you, I worked in a state facility. I did see that she's in a room by herself, because I'm pretty sure that she's going to have a lot of issues in jail. The type of arrogance that she exudes, they do not take kindly to that in prison. And somebody's going to go right in the mouth, right in the kisser. She's going to get it. So, I'm just waiting for the report to come out, and I'm trying to make it into the pearly gates. So I'm not going to kind of even say anything about what I just said. I'm just going to say it. But somebody's gonna knock her straight, pow, right in the kisser, and then I'll read about it, and then I'll ask the Lord for forgiveness at that time for what I might say, if that should ever come to pass. But anyway, I'm going to just show you guys a little bit of this fool getting on the stand at a hearing prior to her trial. She just couldn't help herself. And then another thing, if you look at my thumbnail, and I just realized today, and I said, wow, I did not realize that she had on pink handcuffs. I love it. I love it. All right. So let's hear what this fool has to say. This judge, up until this point, hadn't heard all of the interrogation video, but at this point, he watched the interrogation video, and though he remains mild-mannered, his attitude has definitely changed. He is a no-nonsense judge for me watching this trial. I do. And watching, I don't know how I missed this hearing. I'm just like, but watching all of the hearings that led up to this, except this one, he was very respectful to her. He respected all of her wishes to, he had to put his foot down and say, you know what, enough is enough. I'm not going to appoint another attorney to your case. You're going to have to take, go to trial pro se. I am no longer prolonging this trial. So pro se means that she would have to represent herself. So this attorney, Mr. Owens, he was on YouTube. And he went live on YouTube and said, do you guys think that I would be crazy if I would take Sarah Boone's case? Everybody told him, don't do it. Mr. Owens, don't do it. Run. But I understand, he had some issues, along the lines with, he wasn't able to practice for a minute. So he had some cash issues. So here we go. But he was a true advocate for Sarah. He went overboard. And that is all I got to say about that. Like, this is some real crazy ish, but she's about to get on the stand like she's Mother Teresa. Hallelujah. She's not. Premeditated, and he was abused before he was unalive. The man was like, I think they said he was about 94 or 95 pounds or something like that. To watch him in the video where he was in a fetal position, it is very disturbing. And you can see, like, kind of see his bones. He had issues. She had issues too. They both had, alcohol issues, but she was the aggressor in most of these cases. And also her ex-husband said, yes, when they were together, she would abuse him, especially when she was drunk. So Sarah, we're not food. You are where you should be. If you do the crime, you had no right to unalive that man. You had no right to act like you were the judge, the jury, and the executioner. So rest well in your new forever home. I don't think we'll miss you.
Judge, I would like it reduced. Even more cases.
Mr. Owens, let's go. This is too much. Stop with the theatrics. I just like to see her walk up to the stand in her handcuffs. Because, yeah.
And what is it that's been marked as Defense Exhibit B?
This photographer hates her. That's her good side, though.
Any objection?
Same objection. It's your phone.
Is it the form as of now, or is it the form as of 2020 when the...
She should be. Look, I'm going to skip past
Please.
Mr. Owens because he's doing too much. You don't, Mr. Owens, let's go. Like, what are you doing?
Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument?
Let me speak, Mr. Owens.
I'm going to sustain the relevancy objection for the same reasons that were articulated previously.
She's where she needs to be. Like, hey, what happened to me? What happened to my camera? My camera is not. Oh, okay, that's all right. And it's just, it is just the blackout. What is going on? Oh, my camera turned off. Hold on. Hold on, y'all. Let me see what is going on with my camera. That's because it's saying that it's on. I don't want to use the iMac camera because it's so cloudy. I don't know what's going on. Like, this stuff don't like me. I don't know, and I don't care. But let me just get. Let me move Mr. Owens along, because like all these theatrics, but I just don't want to go past the part where. Okay, so he's talking again. So hold on. Let's see what he's saying on behalf of Sarah Boone, the Red Rummer.
Defense is one.
He's still going. Judge Kranick, why are we going to do this?
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
She couldn't help herself, poor thing.
She was previously sworn at the beginning.
Poor thing, she couldn't help herself.
Judge, I'll be here.
Yes, sir.
All right, so let me just turn this camera off.
Hang on, the deputy's got to move her.
Black spot down there on the bottom. Can I do it over here? No, it's not. Oh, why did I do that? I'm sorry, y'all. Yeah, walk up there. Yes, yes, yes. All that. We want to see all that. Don't even put your hand up and swear because you're a liar. Don't do it. Don't do it. You're going to go.
Ma'am, you've already been
You're
sworn.
not going to make
Counselor,
it
you may
into
proceed.
the pearly gates. You're not going to make it,
Ma'am, would you
Sarah.
please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. I was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking me from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated.
I am not going to let you, Sarah, sit on this stand with this BS. When they came to your house, you didn't mention your son. You were worried about your two dogs, one of them deaf, one of them blind. I'm not making light of Helen and Keller. I believe that one of them name was Helen, the other one name was Keller. That's not true. I'm joking. But she did not mention her son. I just want to let y'all know. On video, when they came to her home, she didn't mention her son at all. She just mentioned her dogs. Her dogs meant more to her than her child did. So she can sit on the stand like she's Mother Teresa, but she's not. You didn't mention your son when this was going on. You were, and she's going to admit that she was drunk that day. If you watch the interrogation video, she's like, not me. I wasn't drunk. George was drunk. Yeah, I had 3 bottles of wine, and it wasn't the small bottles. It was the big bottles of wine. So Sarah, knock it off, because we're on to you. I can't stand her.
To a degree.
Objection, Judge, move to strike. This is outside the motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But we're-
Her interrogation is the next day.
The state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
I'm going to sustain the state's objection.
Relating to the intoxication?
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it. Objection sustained and stricken.
Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive?
Speak up,
after you had
Sarah.
spoken
You can talk
initially
louder
with
than that.
Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the the 2 detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Koespel asked me was if I owned a phone.
And what did you tell them?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Koespel.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
She's lying.
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Koespel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right. Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to
They didn't have to at first.
videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
They didn't see the videos at the
All right,
scene.
after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Koespel?
I did.
And whose phone did you use?
Former husband, Ryan Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Koespel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was
Now,
there ever any talk
Sarah-
about you coming to the sheriff's department the day of this event?
No.
Sarah,
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Koespel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
Um,
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her.
yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
Irrelevant.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Oh. You may answer the question, ma'am.
Did you call for a yes or no? She said yes, and now I don't know like what's pending and how to check.
Did y'all have discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Koespel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator, where did you go from there?
He brought me into a small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got.
I'm sorry, y'all. I gotta interject here. You stupid You asked them people when they was going to give your suitcase back after you used it as a coffin. That was one of the things you asked them. And then you asked them regarding the funeral, should you call his family to make the arrangements or should they? And they looked at you and was like, we don't think that's a good idea for you to call his family. So if you were so scared of his family, why would you ask them, should you call them to make funeral arrangements or would they? Sarah, stop.
The recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Right.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you
What's
feel?
the point? Like,
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
she's lying.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said, normal protocol.
Yes.
Is that what she had said the day
She
before?
said she was very polite.
Normal protocol.
Yes.
And she said the same word, but you said normal protocol to her.
You're a liar. Wow.
So she read the Miranda rights to you.
Okay.
Except number 9.
Except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read, having these rights in mind, you agreed to speak to me now.
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she went right into the questioning?
She did, correct.
So she never got the answer from you, do you agree to speak to us now?
I was never asked that.
I'm trying to figure out what his point is. Like, you're not making sense, sir, at all. This is not the trial.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Yeah, like, what the
Sustained.
fuck?
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space. She was.
That all goes to whether or not-
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors.
Take
that
him to
under
school,
Ramirez as
Judge.
whether or
Take
not
him
it
to
was
Judge.
custodial.
Take him to school. Take him to
Well, I
school.
know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, I think
Exactly.
it goes subjectively to her and what she was feeling, if she had free choice or not, based on
Subjectivity matter.
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
That's a shame.
Did you understand you were not going to get your phone back until you answered
Did
the
you
questions?
forget everything you learned in law
Sustained.
school?
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
Did not.
Did you know that you were going to be arrested?
Did not.
Did you know that you were going to be questioned?
Did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us.
Rule.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? You consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Koespel that afternoon?
One more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Koespel that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and
He said
perception is
it
pertinent. And I'm
affect
asking you,
your
did the alcohol that
memory.
you were under the influence of affect your memory or perception of the events that you
Yeah.
testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect?
Well, now she's
My answer?
stupid. Now she's playing stupid. Come on now,
Judge, I
Sarah.
don't think she understands the question.
I don't.
Okay.
It's been asked for you.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she
You don't know.
said she didn't know
What are the legal grounds of your objection?
I would join.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding the.
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Koespel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witness today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the limit. I agree with all that. We just got through at the jail, meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I'm not specifically asking her what she said that was different, and obviously if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we've all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone is seated, we can proceed with any argument.
Okay, so
And as the court identified previously, I have reviewed all y'all's authorities that were
It's a
provided.
bunch of hogwash. I just wanted to watch this, and I was going to do a video on it, but being that I was still up, I decided to just go ahead and just do a live, and because I don't know how I missed that hearing, but I did. And so Sarah Boone is a liar. she changed her story so many times. But they were able to piece together the truth. Now, the thing about the video, this attorney just said, asked her a question about the day of the unaliving. Did they? He asked, did they watch the videos the first day? He's very this attorney is very I gotta figure out the word that I'm trying to say about him, because that's not what that detective said when she was on the stand. That's not what we saw. All of this stuff, the scene, at the scene, everything is on video, which is the best evidence. And he's standing up there trying to change. He did it all through the trial. I mean, he drugged George through the mud. It was disgusting. I'm still upset about that. One reason I'm upset about that is because his mother got up to say her impact statement, and the first thing she said was, Sarah, I'm not mad at you and I forgive you. And, for her to be so kind to even be able to still say those words to you, regardless as to what type of troubles that her child had, how old he was, or whatever, for her to come at you that way during her, and say that to you first, and for you to get on that stand and freaking rip their whole family apart. It was disgusting. It was heartbreaking. And my heart still goes out to them. And so I just want to also let you guys know that she was offered a plea deal of 20 years. Sarah is a narcissist, so she never admits to anything. I know a couple of people like that. They never admit when they're wrong. Even when they know they're wrong, they're never going to say, I'm wrong. They're never going to say, oops, my bad. Never going to say any of that. You'll never hear them say any of that. So it was horrible. It was just so horrible. I felt so bad for the family. What she said about them, like things she said, like things that weren't true. His children weren't in the courtroom. They live in another state, but they were on Zoom. And his oldest daughter spoke for all the children. He had 3. And what she said was, that was my father. I loved him. He taught me many lessons. I'm going to miss him. So regardless as to what type of issues George had, his children loved him. His family loved him. His family begged him to stay away from this evil, vile woman. And like I said, he was abused in any way that anyone else is abused. And it takes a person that's being abused. They say 7 times before some people actually leave. And so it was a build up to this. And the sad thing is that the police asked him, George, we know that something is going on, but you're not telling us. We can't do anything if you won't tell us. You're bruised up, but we have to take you to jail because you're here. It got so bad that officer said, and it's on the video, that they called George's job. He had a job at Ace Hardware. He lost his job shortly before he passed. So when Sarah tries to say, oh, he was just a piece of what, and he didn't this and he did, he worked. He had a job at Ace Hardware. And what happened was the police got so tired of her using them as a weapon, because she weaponized the police department. Woe is me, I'm a battered woman. And I don't make light of victims. I've had my own thing going on, but my mother taught me, if a man puts his hands on you the first time, out the door. And so that's just what it is with me. So I know a lot of women aren't that strong enough to do that. But she weaponized the police and department. So the police officer actually called George's job, and George didn't know that they called the job, and asked his boss, was George there today? Yes, he was. Did he leave? Did he get off work? And the person at the store, the manager in the store, said, well, he didn't leave at the time that he should have left. He left early because Sarah called and asked him to and told him that she needed him to come home. So the cop said, like, listen, George, we called your job. We know this, but we can't do anything if you don't tell us. He was an abused man. Nobody can tell me different. Nobody can change my mind. Just watch the trial and just watch when she's on the stand. And please watch how she explains why she hit him with the bat. Because he was in a suitcase. She zipped him up, but she was in fear of her life. Does that make sense? It doesn't. But anyway, I cannot sit here and try to make sense of something that does not make sense for you. It doesn't make sense because she's lying. So with that, I'm going to go ahead and head on out of here. And I'm actually going to try and get some sleep, take my mind off some things that, I have to get up tomorrow and let's, do some stuff all over again. So I'm going to close the show out the way I normally close the show out. And I'm going to tell you all to please get your mammograms. Make sure you fill your boobies to make sure that you are all right. All right. And don't you dare let anyone come into your house and disturb the peace that passes all understanding. I am Survivor Speaks. I'll see you guys somewhere in these YouTube streets or on the Twitter or the X, formerly known as Twitter. If I go over there, I'm not over there much, but I do check over there periodically to, I go to Thugger Daily to see if there's any YSL updates. He gets the minute by minute plays on what's going on with that trial in the second half of that trial. So even though they're not going to trial as of yet, they still are filing motions for that trial. That's how we know that Yak Gotti's hearing is not until February the 7th. So he's sitting he's incarcerated as a man that has been exonerated, found not guilty of every last one of the charges that he had. But because Fulton County is playing dirty and they got the judges playing dirty. But you know what? Just sit back, relax, because Fonnie, I think you're going to have some problems coming up, and they have already started. If you haven't watched the trial, watch the trial, please. If you have, everybody has men in their family, so you need to watch this trial just to educate yourself on what's going on down there. Even though 2025, what is it going to bring? I'm glad 2024 is out of here, but what is 2025 going to bring? It is not looking all that pleasant, not to me anyway. So, like I said, make sure you get those mammograms, fill your boobies, and make sure you're all right. I'm Survivor Speaks. I'm out of here. I will see you guys in the next upload video or in somebody's chat if I visit. See you later.
Full cycle, I just might though just like a Michael. Mama gone now, I'm thinking death is not we entitled. And it was me versus me, them battles had to fight through. And when you way in the dark, them demons try to fight you. But you can't let them when you gotta see the damn light. Diabetes came from nowhere, messed up whole life. That's what I used to think, my mama helped me out. I got one dear and that's gotta make proud, don't count me out. Let's get it started, rest in peace my mama, I don't wanna talk. Fresh fit, who that little nigga, fresh the way he walk. New drip, I'm that one dude creating all the sauce. News flip, you that one do the worker, not a boss. It's safe to say that after all this, I'm standing tall. It's safe to say that after all this, I'm still gon' ball. It's safe to say that